Greetings to each and every one of you. Welcome to today's program, How to Find and Foster an International Family Law Expert, sponsored by the International Section and the Family Law Section of the New York State Bar Association. We would also like to thank our co-sponsors, the American Bar Association International Law Section, the DC Bar Family Law Community, and the DC Bar International Law Community. And the New York Women's Bar Association. Without further ado, help you welcome the International Family Law Committee co-chair of the NYSBA International Section, Ms. Melissa Kaczynski. Melissa?
Thank you. I'm going to pop up my PowerPoint. Okay. Can everyone see that? Can my co-presenters see that? That's most important.
No, not yet. You have to
Not
click share
yet.
screen.
There we go. How to get the Zoom. I know how to do this. I promise. It's been a long COVID. And then since then, there we go. Okay, that makes much more sense. I hope everyone can see that now. Okay, I see nodding heads, so that is good form. All right, so welcome. As Cara said, that I am the co-chair of the NYSBA International Family Law Committee. That's in the international section of NYSBA. So we really welcome you to this program that we're putting on today. Many family lawyers need an expert for their international family law case, but it can be daunting to determine the most appropriate and competent person to serve as an expert witness, how to prepare them for your trial, and how to maneuver the multi-jurisdictional differences that are inherent in an international family law case. So I am honored to be joined by some extraordinary international family lawyers today who are going to share their top practice points for finding and fostering an international family law expert. They have graciously agreed to let me lead them through a discussion on this topic, and I am really grateful they're willing to share their expertise and experience with everyone today. If you need counsel in one of their jurisdictions, they are the person you should contact. They're brilliant colleagues, and they're some of the most collegial individuals that you could ever hope to work with. So I'm going to now introduce you to our experts, and then we're going to hop right into our discussion. The first is Elizabeth Carson. She's a partner in the family law team of Pennington's Manchis Cooper in London and a dual qualified lawyer in England and Wales and New York, and frequently acts in cases with a US or international dimension. And then we have Kelly Schindel DeLacy. She's a partner at DeLacy Rybel Schindel in San Francisco, California. She's a certified family law specialist in California, and she concentrates her practice on complex cases involving apportionment, property, business valuation, support, and custody, among just about anything else that you can throw her way. And then we have Mudita Chawla. She's a partner at Chemtob Moss Foreman and Beta in New York, and focuses her practice on high complex cases, including cross-border and high net worth clients. She is a whiz at registering and enforcing foreign custody orders. I know that for a fact. And I'm Melissa Kaczynski. I focus my practice exclusively on consulting on and mediating complicated international family law cases. So as I said, we broke down our discussion today into 10 practice tips that are going to help us focus our discussion on what all of you, our colleagues, need when you're finding and then working with an expert on an international family law case. If you have questions, I will be monitoring the Q&A. If the question comes at a time when we can address it right then and there, we'll try to seamlessly fit it into our discussion. Otherwise, I will keep tabs of it in the hopes that we have some time at the end in order to address it. So if my co-presenters are ready, I'm going to dive in and start talking about our tips. Tip number 1, start looking for your expert from the first day the client walks in your door, because experts are involved in more cases than you realize. So I'm going to start by seeing if Kelly has some thoughts on this tip.
Sure, and I guess it's good morning for me in California. Good afternoon for everyone. I have a policy both in my international cases and my local cases we call it front loading in my office, but ultimately really looking at the very onset of a case at the potential issues that come around. Well, in international cases, that can be pretty complicated. Oftentimes I start with a consultant like Melissa or someone similarly situated to help me kind of navigate the particulars of the countries that I'm dealing with, because some of them I'm more familiar with just because of my prior experiences and I know who to go to. But but others, I may not have much experience. The reason I do this right away is not just because I am a specialist in California and I don't know anything else. That's not really it. I think the example for me is really has to do with having and understanding what courts in not only what the court will do in my jurisdiction, but in the other countries that are involved. I am involved in a case in Japan, and it became very clear to me as part of their processes that they were going to be, and then they issued orders that they were going to be applying California law. And they were looking to me, for example, to explain to the courts what California law is and how they were going to apply it. The real issue wasn't that I couldn't explain it. It was really a cross understanding of those concepts, because the concepts that we have in California are completely, for lack of a better word, foreign to those in the Japanese court systems. So we've had to spend a ton of time writing, rewriting, translating different pieces of information. And honestly, a lot of that work that was done has been done at a rush because I was brought in later on. So to this particular point, for me, I don't like to rush. I'm sure that you all don't either if it's not completely necessary. And having those folks involved right away, whether that's just a consultant or also the related experts from the countries involved, is key so that you are not missing a step, whether that's procedural or otherwise.
I think that's a good point, because we're not as used to that in the United States, that the law of a particular country might apply the law of another country. There are a lot of situations where you're actually needing to opine on a law of a very specific jurisdiction. But in addition to that, there's a whole host of other experts that you might need. I mean, Mudita, did you have any sense of some examples?
I did. I had a Hague abduction case between New York and Iceland. And one of the reasons why the party left Iceland with the children was because of the lack of her ability to get proper Icelandic immigration status there and her inability to work. And from the moment she retained us, that became such a pivotal point of our argument for why her removal wasn't wrongful. But we needed to have an Icelandic immigration attorney as an expert who we found at the very beginning so that we could understand the Icelandic law, so that when we were presenting our papers, when we were writing our papers, we could incorporate the proper law into the papers to explain to the court why the removal wasn't wrongful in the first place. And then when we had the trial, we had that same expert testify to explain to the federal judge in New York what the Icelandic law is and why my client in that particular case could not obtain work permission in Iceland, which made it very difficult for her to be there and support her children if she was forced to return to Iceland.
So it involves really assessing the case at the first instance, like Kelly was suggesting. What all do you need? And then actually we're going to get to this point in a second, but then finding the person. Before I get to that point, there was a question that actually is a really fascinating question, and I'm not sure if anyone has thoughts, and I certainly could jump in. Could these matters potentially involve the unlawful practice of law if not navigated properly? Yeah, I see Kelly shaking her head and saying yes.
Another reason why I front load it. I mean, to be very honest, it's got dual purpose. It is both best for your client, and sometimes they don't like to spend the money up front, but you need to explain to them that it's going to be better for you in the substance, but also malpractice wise, you don't want to do that. I mean, even simple things like service, right? If you don't, the service rules and how you accomplish that is extraordinarily complicated depending on where you are. And you need to have somebody help you do that right way. For example, if you don't do it right, then you're at risk.
So let's go on to the next tip. The next tip, finding an expert may be difficult. I think that seems obvious based on what we've already been discussing. So you need to start leveraging colleagues in other jurisdictions. We have three amazing attorneys right here. You have to cast a wide net and do your research. So I'm wondering, Elizabeth, if you have any thoughts on this particular tip.
I do. I have lots of thoughts on this tip. And to Kelly's previous point, I would add also, I think it's a great idea at the outset to be thinking really holistically about your case, and that clients appreciate it when you flag to them, I think, from the outside, both for costs and other reasons, that you think something is going to require expert advice from lawyers in other jurisdictions. But moving on now to finding an expert. Absolutely. It can be very difficult. I think leveraging your networks is really important. I'm going to come on to that in a minute, but I think you have to be sure that you know what your expert's qualifications mean. So, for example, if you're looking for someone to opine on French family law, a French notary, for instance, is perfectly well placed to advise on a French marital contract, and they can advise on a consensual divorce in France, but they are not a practicing family lawyer in France. And I use that just as one example of actually you having to do due diligence to make sure that you're finding somebody who is actually best placed to provide advice. And often that's a practitioner, but not always. I think a really critical question that you need to ask is whether or not someone has produced an expert report for the court before, whether that's a written report or whether they've given oral evidence. When you're dealing with foreign experts, you need to ask yourself, is this someone who's worked in a common law jurisdiction? Have they worked in an adversarial setting where their expertise has been challenged? Ideally, you'll find an expert who's actually worked in your own jurisdiction, so they're familiar with the practice there. But if not, I think you need to make sure that this is somebody who is going to be comfortable in that adversarial setting, because a lot of experts are not going to be used to that, and you want to be able to rely on them and to have them be, compelling in the evidence they put before the court. And I think the next thing to think about is to make sure that if you're looking for a particular expert, that they have the expertise that you need. If it's a business valuation, are the concepts that you're discussing or that your client thinks are important, are those concepts that that particular expert understands and are within their standard area of practice? One of the things that's helpful is if there's a particular standard or hallmark that you use in your jurisdiction, you could look for an expert in another jurisdiction who uses that same standard. I'll give an example from England. There's something called the Royal Institute of Chartered Surveyors. So they do property valuations in England. That's a very well-known hallmark. And I know for my English judges, if I'm valuing a property in Russia, if I find an expert in Russia who has that same RICS accreditation, that an English judge is immediately going to see that and respect and accept the valuation that's produced. So look for those international standards and hallmarks where you can. And I think finally, I just add, in terms of finding an expert, there are, organizations like the International Academy of Family Lawyers, which are going to be incredibly useful to you. But there are other organizations. There's a UDAEFA, which is for Latin American family lawyers. There is the International Association of Young Lawyers, the Commonwealth Lawyers Association for Commonwealth countries and a lot of African jurisdictions, and there's the IBA. But don't forget also to leverage your own professional networks. If you have valuers you work with in the US frequently, or other lawyers, ask them who their contacts are. They may know accountants, business valuers, other lawyers in other jurisdictions. So use those networks that you already have to help you find an expert.
Yeah, I've gotten calls from not Elizabeth, but her colleagues over in England, and in the US, it's much more complicated. Everything is state law based when it comes to family law. So they're saying, well, we have a piece of property sitting in South Carolina, and we have another piece of property sitting in California, and we need to know what the law says in this jurisdiction in like Illinois about this issue. And it might be that I need to be reaching out to multiple people, because family law is domestic law. And so when you're giving opinions on law, as opposed to say a value of a particular asset, like Kelly and Medita were suggesting that they've used legal experts, family law is domestic law. And so it might be that a local lawyer who knows and practices the domestic family law of a particular jurisdiction is best situated. Whether they end up being your advising expert or whether they might be a testifying expert, we could certainly discuss about that. One more thing I wanted to point out, though, because I know that all of this costs a lot of money. And when I was looking through those who are attending, and there might be legal aid organizations, it is hard to come across all of these vast experts when you don't have money to pay for them. So most of what we're going to be discussing involves a lot of money, but I mean, there are some organizations which you could still reach out to colleagues about. International Social Service has offices throughout the world that might be able to do low or no cost home studies. The National Center for Missing and Exploited Children in the United States might have a roster of experts, psychologists, social workers, things like that, that could help in some of these cases that have a focus on cross-border matters. Are they the best expert? I mean, that might be your judge as to whether no expert or a low-cost expert that might be less than superb or even a full-cost expert that might be less than superb is best for your case. Okay.
That's a good point. I mean, one of the things I just on this particular tip is that I really look to my local people first, because oftentimes that concept of what Elizabeth was saying about really applying, how do we get an outside expert that is applying their standards, which is what we should apply, but be able to communicate with our courts, which have a different understanding and definition of how things work, whether it's an appraiser or a forensic accountant or a psychological expert. We need them to be able to speak the language, which we're going to talk about a little bit more later. But that's one of the reasons why I start at home and say, okay, do you know a real estate appraiser of folks in Germany, or do you how do you deal with this issue if it's cross border? And they usually have some ideas.
Right. I mean, and that goes right into tip 3, Kelly, if you want to address different countries set different standards for choosing an expert, become aware of what standard is used in the courts where part or all of your case may be litigated, because of course, in an international case, you might have multiple court cases in multiple countries that might require expertise.
Right. And then to add to that, if there's multiple countries, but there is also multiple states, then there's also different standards that those experts are held to. So again, having those experts in each individual area, or at least a consultant to give you that information, is key, so that you don't mess it up for your client and also for your own exposure. In some jurisdictions, for example, and I think Elizabeth can talk a little bit more about this, but the standards to select a joint expert, while in others we choose competing experts, or even that the court can invite its own expert on top of the parties having their experts. So you really need to understand each jurisdiction that's involved in their different standards for what qualifications and background that they require to be able to give an opinion that is reliable and can be really deemed as admissible evidence and help your judge get to the right answer.
I mean, in your jurisdiction, Kelly, do you get to request, say, a CV in advance or a written report in advance? Is that a mandatory or something you can request?
Yeah, if you have a trial, you have a deadline by which you have to exchange your experts. You do a demand, and then you have the deadline for exchange of experts and reports, which includes not only the CV, but anything that they're basically going to say. You have the opportunity to depose them. And it's interesting because you can also we have kind of a dual approach. If the parties are somewhat collaborative, we will start with a joint expert. And that joint expert is not taking one particular position, but is to do essentially, the math for both folks. For example, if it's a forensic accountant, and then if somebody has a real issue with that joint expert, they can bring in a person to tear apart their report and explain why the person that they hired initially wasn't the right person. And I honestly have had one case where we had a joint expert. The parties were arguing about the different positions that they wanted to take, and the judge brought in their own And that's one of the reasons why I brought that up, because they hired their own, we call it Evidence Code 730 expert, where they were able to have that person advise them as to what each team was alleging, which was fascinating to me.
A bit overwhelming as well.
Yeah, and there's like I said, I mean, I've had depositions in the middle of trial where an expert hadn't discussed a certain issue, and the court said, okay, tonight you're going to go and you're going to have the opportunity to ask that expert questions, and then you can come back tomorrow.
And I mean, in US litigation, you have to qualify an expert when they're testifying. So you get to voir dire them and ask them certain questions about their credentials. I mean, I just recall from a situation where I was testifying in a case, I was to be qualified on parental child abduction prevention, whereas one of the parties was trying to contest me as an expert because they thought I was going to opine on Egyptian law. But that was absolutely not what I was going to be qualified on. And the lawyer that hired me was very clear, and I was very clear as the expert with her. I cannot opine on Egyptian law. I mean, certainly if you want to spend $1 million instead of hiring an Egyptian lawyer and have me go to Egypt and study Egyptian law, maybe I can be your expert. I mean, that wouldn't necessarily be the unauthorized practice of law, because I would be protected in at least my jurisdiction under, expert rules. But I would have to be an expert on Egyptian law. So, I mean, it's you get into the whole credentialing parts.
Well, and as part of the standards, you really, I mean, it can get even more complicated. We had a recent prenuptial agreement that the parties were international now. That was the ultimate decision. They also had a home and residence in California, and the prenuptial agreement applied New York law. So we were looking at all of the different things, and we realized that the standard to be an expert is different in New York than it is in California. So we had to do different analysis, and we had a whole bunch of, I guess, pretrial motions to try to get to the end of how to apply it. But I needed to bring in New York counsel and then also counsel from
all those conflicts of law stuff causes me to geek out. So tip 4, communication's key. Find an expert that is a clear communicator. I mean, this seems pretty common sense, Mudita, but I mean, it is overlooked a bit in international cases.
It is a lot. And this really piggybacks both off of what you were saying and what Kelly was saying earlier, that when you retain an expert, the goal you want is for the judge to be able to believe your expert and hopefully rule in your favor, right? Which we all know is the right ruling because it's in your favor. And the best way to achieve that is to make sure that the judge, number one, understands what your expert is saying, that your expert is able to explain properly and appropriately to the court what it is you want them to understand, and whether that involves explaining the law in their respective jurisdiction, whether it involves explaining concepts of law. Like Kelly said, in Japan, the system is completely different. And if you have a Japanese expert testifying in New York, you need that expert first and foremost to explain what the law is in Japan in a way that is digestible for the judge, so that the judge can then start thinking from that perspective. And the best way to make sure that your expert is a clear communicator is really for you to do your homework with your expert. Make sure the first time you speak to your expert, you're clear about what you're going to need them to do. And again, this goes back to, are they going to just be a consulting expert? Are they going to be testifying? Obviously, if we have the judge involved and you want them as a testifying expert, what is their proficiency in English? Can they do this testimony in English? And if they can't, make sure you get a translator. Make sure you get a translator who is a well-versed and proficient translator who will be able to explain the concepts properly. I mean, I've been in court many times, and because I speak a few other languages, I hear what the translators are saying, and I'm like, that's just not what they said. It's not an appropriate translation. So it's important that, again, from the very outset of your case, that you consider all these things so that you can tee your case up to get the best success and to get the best results for your client from the very beginning.
Yeah, that takes us right into, English skills, and we're all English speaking native. And we would litigate our cases in our jurisdictions in English. Elizabeth, I mean, what do you have to say about experts that naturally would speak a different language?
Well, I have to agree with everything that Medita has just said about really, getting to know your expert very well from the outset, trying to ensure that they are comfortable in English. And if they aren't comfortable in English, making sure that you've got a good interpreter that you can work with. I think it's really important to have those conversations with your expert as well, not only on a sort of conversational collegial level, but also to make sure that they are going to be able to be, if they want to give their evidence in English, make sure that they're not just saying that because they think that that's what you want to hear about their English, and make sure that they can be comfortable on a professional level and in a professional setting in court in speaking English. And if not, have an interpreter from the very beginning. I think the other thing that I'll say as an American, having lived in England for the last 20 years, is make sure that your expert actually understands you. Sometimes people who've been taught English by an American will have trouble understanding somebody with a British accent, and vice versa is also true. So make sure that your expert is going to be very comfortable, not only interacting with you, but also with the judge and everybody else that they encounter in the courtroom in the process. And I think the other thing is it's really important that they understand what are the key terms that you use in your jurisdiction to describe, particular aspects of the law. Obviously, they need to give evidence. They're going to be giving evidence about what the law is in their home jurisdiction. But if you don't use the term custody in your jurisdiction, we use child arrangements here in England. So they need to understand what does child arrangements mean, so that when somebody asks them a question about it, they won't, look blank at when asked. And likewise, we don't use the term alimony here in England. So again, part of educating your expert is making sure that they understand the key terms and concepts that are going to be integral to them giving evidence in your case.
Well, that's so important, because some of the terms of art don't translate well, just even if they're all in English. The concept, the legal concept in, say, England and California might be completely different, even though you're trying to fit them together and make them the same.
Absolutely. And I think sometimes the people, I'm not sure who came up with the phrase child arrangements, but I'm not sure that necessarily would leap into people's minds and make them think, oh, this is about actually contact, custody, etc. It doesn't naturally sound like that. It sounds like something that could be.
And if you're a Texas lawyer and you're getting a conservatorship order, which is what we would call a custody order in DC, whoa, that word might throw me for a loop. Now, we had a question, and that actually is interesting, because some people whose native language is non-English, for example, in our experts, they might be more comfortable writing a report versus testifying orally. I know in my courts, unless the other side might stipulate to the report, we're going to probably have to have them testify orally as well. I mean, what is the difference between, in your jurisdictions, about writing a written report to the court versus giving oral evidence? And how does that play into the English translation thing to make this maybe easier for the judge to understand?
I was going to say, in England, the starting point is always that there is a written expert report that's provided to the court. And we do have a system of single joint experts here. So the family procedure rules state that you have to have a single joint expert. It's possible to later challenge the expert's report to seek to adduce a further report, but the starting point is always that written evidence from the expert. The parties ask questions about it. And then when you go into your trial, you have a discussion with the other side and sometimes with the judge as to whether or not you then need to hear oral evidence from that expert. So the starting point is always that written report, which you want to be clear and concise and well written in English. But again, there's always the possibility that somebody gives oral evidence as well. And for that, they need to be comfortable in English, or you need to have the foresight to have thought about an interpreter for them.
Yeah. And I mean, Kelly.
Sorry, in California, we don't have to have a report. If you're going to have a report, you need to produce it by a certain date. But you can if you're going to be a rebuttal witness, for example, You don't have to have a report. You can and will get your deposition taken, and they have the right to understand what you're going to testify about. But sometimes strategically, we don't produce reports, particularly in those circumstances. The other point I was going to make about just the communication skills with regard to English writing and speaking skills within the jurisdiction, even more narrowly, I would really find out how your particular judge likes it. I've had it where I understood there to be a report and this is going to be my expert, and I presented them, I listed them on a witness list, and the judge very kindly said, I know how to interpret law. I'm fine reading the law that you have presented to me. I do not need to have somebody come up here and tell me that. So I mean, that was a lesson I had to learn. So I make sure I find out what the judge likes before I embarrass myself, which is how we learn.
It's so fun being the expert when the judge really doesn't want to hear from you. I mean, it really, really is.
Well, I mean, judges know a lot, right? So they think that they can also interpret English law or French law or New York.
I'm wondering, and when you're crafting your strategy about whether you provide a written report or not, whether or not part of that analysis is, will a report in English or a translation of a report into English actually be more persuasive than what my expert could testify to orally?
Melissa, I'd like to just add one other thing on this issue is I have encountered a lot of experts from different jurisdictions whose English is impeccable, whether spoken or writing, but because they come from a jurisdiction that doesn't have the adversarial system of law, the cross-examination becomes very difficult for them. And even though they're experts, even though they've been practicing for a very long time, it's very hard for them not to do what a lot of our clients do, which is take the bait on cross-examination. And I think that also goes back to really being in communication with your expert, explaining to them how your system works, even though we are asking the court to apply their law, so that they don't fall into those traps that witnesses sometimes fall into just because they want the court to see that they know what they're talking about and they're right. And they're not going to stand for this upstart attorney asking them questions and putting them on the spot. And it's not okay. You know, but that in the end ends up hurting your client if your expert can't handle that cross-examination technique that we know a lot of us, including myself, use.
So that's interesting because that goes to our next point, understanding your expert's expertise. And part of that, in addition to their substantive expertise, is their ability and their expertise on having testified before. I mean, Mudita, do you have thoughts about, you know, finding that expert and knowing and understanding and educating them about what you intend for them to be an expert on?
And that's absolutely right. And it's also important, again, this goes back to trying to get your expert involved in the case as early as possible, because if you are crafting documents, if you're crafting discovery requests, if you're doing discovery responses, involving your expert in those legal documents so that you can set up your case again to have the most information, make sure that you are responding appropriately with your expert's help becomes very, very important. You know, and again, this really goes back to the earlier you can get your expert involved, the better you can help establish your theory of the case and make sure that you are acting consistently in your client's best interest throughout.
Yeah, no, I agree. And you know, there is a comparison almost. Presumably, you know or will know who the expert is on the other side if they're going to hire an expert. So you have some ability to weigh your person's expertise against them. There might be some questions as to whether, you know, you can change experts if for some reason your expert doesn't stack up in terms of substantive expertise. But it's a real dance to find the proper person and then to educate them. I mean, in my jurisdiction, there is also designations of experts due by a certain deadline to the court. And when you designate an expert, you have to state what they're going to testify or give an opinion on. And it's amazing how many lawyers will write out a whole narrative of what they think an expert will testify about, send it off to the court without even consulting the expert about whether or not that's really what their expertise would allow that expert to testify to. So there's a whole lot of proper planning when it comes to these cases. Okay, so tip number 7, know the discovery rules of the different jurisdictions in your case. And again, multiple jurisdictions, so potential multiple different rules of what you have to disclose and don't have to disclose. Kelly, what have you seen in this regard? You're muted.
Sorry, I was coughing and didn't. I think I have a theme, and maybe it says a little bit about who I am, but this is a proper planning theme, which is similar to the front loading. I like to be prepared. So that could be annoying sometimes. I understand. But in this particular situation, I think it's essential for you to know the discovery rules and heading into your issues, whether, I'm thinking in my mind about the US courts and how our process is fairly broad. In California, for example, you are required, without even asking a question, to provide all material facts and information about your family law case. That is not formal. That is just part of the disclosure process. We also then have our normal formal disclosure process, which is an open door. I mean, you can go on a fishing expedition. That is something that is completely open, encouraged, and you're entitled to do that. Obviously, you can't harass someone. It can't be completely irrelevant, but the relevance analysis in California family courts is, and almost everything is relevant if you can have even a small example of what it might relate to. I know that gets more complicated when you have a California court, but then, for example, an international, accounts. If you want international accounts in France, that process, how are you going to get that? What's that going to look like? Can you just serve a subpoena? It is way more complicated than that. And you need to understand and know those different rules so that you are not missing deadlines, so that you're preparing for whether it's a hearing or a trial on those issues or settlement. You need to have the information. Getting an expert that understands the rules about discovery in the other jurisdiction, or at least even how to get the initial steps, whether it's statements or otherwise, is essential. Sometimes we start with somebody at home. Well, usually we start with somebody at home that can help us. Ted Folkman is a person that is pretty well known in the US who does a lot of service assistance. He's extraordinarily knowledgeable. Honestly, the amount of information that's in his brain about service is pretty impressive. But you need to find that local person who can understand the discovery process. You're going to be also, for example, tempted to use your testifying expert as a consultant on your case. But in California, your testifying expert's file is completely available for the other person for that deposition. When you're notifying the other side of who your designated expert is, it makes it completely open game there for them to look at your notes, which could expose strategy or other things. I always have my clients only email me, and then I communicate either by phone or Zoom with my experts so that there is no written record. That's essential. I don't know, again, depending on the person that's on the other side, they might not have that same experience and send you a long process analysis in an email, and now you've got that in writing.
Yeah,
it's not. I really try to control that right away, Melissa, so that conversation in our initial meeting, I set up a communication strategy, and we discover what is, for lack of a better word, what is the rule in the location where the expert is located, and also in my jurisdiction. If a person, for example, has a hard time speaking English and they have a better chance of communicating all of their information in writing, I will do that by Zoom and have a translator present, and then they can relay it in that manner. Sometimes I also have like the Zoom with a real-time typing document up so that I can actually understand and ask questions, and we can do like a Google Doc type of thing that just isn't a record of anybody's file. You have to get creative in those particular circumstances, but just really understand the processes in the jurisdictions that you are working within as it relates to getting information, and could, you know, make or break your case.
I think that's a really good point, because well, a lot of individuals don't have the funds to hire an expert to testify, an expert to share expertise with their lawyer and help direct strategy. But the discovery rules can make it highly complicated in the United States. I don't want to profess that every country has as crazy open-ended discovery rules as us. However, a colleague posted in the Q&A that in Trinidad and Tobago, their court rules provide that the expert, although paid for one party as the court's expert, but the expert can't be appointed without permission of the court, and there's no trial by ambush, so that they must have full disclosure before the trial. And it sounds like in California, and I know at least in DC, we have certain pretrial disclosures that must be done on a pretrial statement about all of this. And then, of course, we always have the authority to issue discovery and find this stuff. And then you know, you put out all the strategy, but this goes back to your expertise in having testified or participated in these cases before, because you get the expert, you know, they're like, okay, we were not going to send you a bunch of emails, although some, especially if English is not their first language, email might be their preferred method of communication with you as your expert, as opposed to doing it orally, and time zones may make that complicated. But then, you know, even when you do this Zoom call with your expert, they're taking notes, and their notes might be discoverable. I mean, it is embarrassing when you get to trial and opposing counsel goes to your expert and says, could you please read the notes here? And in the notes is, as you said, Kelly, your entire trial strategy with commentary that the lawyer said about the judge and everything that is just very unflattering and very telling. So crazy complicated, but it needs to be said, because it gets conflated a lot, in my view, with lawyers, especially in the United States, with saying, you know, they're one and all. This expert can do everything for me, and it might be very dangerous.
I know that the discovery in California, our automatic preliminary declarations of disclosure process is very different than the UK, for example. I had a client who was, we were dealing with a Hague issue. They had originally been in London, and the mom left and came to California. We dealt with the Hague here, but their entire divorce was done in the UK. And I was like, well, don't you have to produce all of these records and statements of each and every single? Nope. I had to be educated. So this stuff comes from experience, but I definitely, it's not going to be your gut that's going to tell you what the answer is, and you really need to get an expert to help you.
So Mudita, it's no surprise that all of this, us here in this call are very, very prepared attorneys and like to plan. So how is it that we make things as easy as possible for our judge, and why is that important?
So the reason it's important is because at the end of the day, you want your judge to rule in your favor. And the more work you can do to lead them down the right path, the easier you're making your job in the long run. It's also really important to make things easy for the judge when you have competing experts. If you have your expert, the other side has the expert, how much trial time do you have, and how much time at trial do you want to spend qualifying your expert? Because in New York, we have rules on who can get qualified as an expert, and you have to go through a litany of questions to explain their qualifications to the judge, to explain how long they've testified, how long they've worked, whether they've ever testified in a case like this before, what countries they've testified in. And those questions can eat up a lot of the very little trial time you have. And so when you have competing experts, if there is a way to stipulate with opposing counsel that we'll exchange their resumes, we'll exchange their CVs, yes, we agree to yours, yes, you agree to ours, and then you can get straight to the heart of the issue versus having to spend an hour trying to qualify each expert. That saves a lot of time for the court. And my experience has been that judges like attorneys, even when you're litigating, even when you're in a very contentious case, to try to limit the issues you're fighting over. Let's make the fight about things that actually matter. Now, if you both have experts that are equally qualified, stipulate to it. Do a stipulation written, so ordered by the judge, then the judge knows you're getting straight to the heart of what the issues are. This also means that when you know you need translators, arrange for them before, notify the court way in advance of your trial date that you need a translator. So you're not arriving, and depending on what language you're having translated, there are lots of translators that are readily available. If we need a Spanish translator in New York, it's very easy. The court has a lot of those readily available. However, if you need an Icelandic translator, it might be hours before they can find someone. So giving the court advance notice that, Your Honor, we're scheduled for trial 3 weeks from now. We're going to need an Icelandic translator. Let the court know in advance. Follow up with them. Make sure the court remembers, yes, you have to sometimes harass the court officers to make sure that they know that, yes, and I do this when I'm going into court and I know that I need a translator next week on another case. I'll go up to the court clerk and say, remember, I need that translator, because it makes it easier for them. You're not losing court time. You're not having your client pay for you sitting in court waiting until the translator comes. And again, this goes back to what Kelly says, know your judge. Know how they like things done. If your judge is the kind of person who wants you starting on time, be there on time. Make sure your expert knows who they should be looking at when they're testifying. Make sure your expert knows everything is going to be written down by the court reporters. So they need to speak slowly. They need to enunciate. All the same things you explain to your witnesses and your clients, do the same thing with your expert, because it makes it easier for the judge to then understand them, for you to have an accurate record of what happened at trial, which hopefully will create a better result for your client at the end of the day.
Can I ask a question, Medita? Have you ever done like a preliminary hearing on qualifications so that it takes up?
Our judges don't typically do that because they are so swamped. They're like, we're just going to deal with everything at the same time. And we don't end up having preliminary hearings. You end up, and the problem is if you have an expert who then doesn't end up getting qualified, what's your trial strategy now? Right? Like that sometimes happens where the court's like, no, I don't think this person is going to qualify as an expert. Then they can't opine as an expert. So you kind of need to have a backup, which again is why stipulating to your expert testimony coming in becomes really important.
That's an interesting back and forth. And we have a question that relates to it, because I mean, in my court, almost anyone can qualify as an expert on just about anything. It goes to what weight the judge might ultimately give them vis-a-vis someone else. But do you have any tips about experts that you might feel are not qualified? And this might also go to tip number 10, which we can discuss then. Say, like my prior example, I start opining on Egyptian law, but I'm not an Egyptian lawyer, and I'm there, maybe there's no expert on the other side. How would it be that if I have no training or expertise in Egyptian law, that you help unqualify me?
I think in that circumstance, I would focus really on the types of testimony you have given in other cases and why the court should analogize that to this particular situation and admit you as an expert on this issue.
What about in the UK? Is that like,
I think probably that scenario is quite unlikely, because in England and Wales, we have the expert is the court's expert. It's a single joint expert. And where the parties can't agree on someone based on their CV and qualifications, which is always part of deciding who the expert is, then the judge would make a determination about that expert's qualifications. So it's very unlikely that you'd have somebody unqualified to start with, because one of the parties would object to the other proposed expert, or the judge would say, actually, based on this person's CV, they're just not qualified to fulfill this role.
Fascinating. And that goes right into researching that expert, because Elizabeth, if you're doing a joint expert and then communicating with opposing counsel and trying to select someone, I mean, how does that go when you're researching this person and putting them forth?
Well, you have to be very careful about it, because the first thing to know is in the English system, because it's a joint expert who's producing a report for the court, all of the communications that you have with that expert have to be shared with the other side. So if there's a telephone call with them, there has to be a record of that telephone call. If there are email communications, those have to be made with the other side in copy. So there's complete transparency when you're talking about a joint expert. And the thing that you have to think about, and this comes back to what Kelly and Medita have said about preparation, is actually when you're trying to decide who that expert is, you have to say at the outset, well, if I don't know the answers that the expert is potentially going to give, but how do I find those out, and what tools can I use? And sometimes that's in the form of what you'd call a consultant in the US, and in England we refer to those individuals usually as shadow experts. So, for example, I had to instruct an expert in Romanian law a few years ago. I knew that the court would need a single joint expert report, but I didn't know anything about Romanian law. It wasn't an area that I felt comfortable opining on at all. So I instructed a shadow expert to help steer me and guide the questions that I needed to ask to the joint expert who was going to be preparing a report for the court. But I think there's been a lot said about sort of thinking outside the box. And if you don't have the money to both instruct a joint expert who you're paying for 50% of their costs, and your own shadow expert whose costs you're paying 100% of, well, what other approaches can you use to help you work out what are the questions you need to ask to the expert? And one of the things that we should probably all be thinking more about is AI, and using that as a tool for actually determining what it is that the expert might eventually say, and guiding us in the questions that we put to that expert. So I think that's something that's really important. And I think the other thing I would say is when you're working with your expert, you just have to be very conscious of what the rules are in the particular jurisdiction in which you're operating. And again, that point in England, you have to be very careful about what's said to the expert. You know that it's going to be shared with the other side, and vice versa. And in England also, we're not allowed to prepare our experts for giving evidence. So you can't you can talk to them about, what is going to happen, sort of ABC in a court, but you can't have them run past you what they're intending to say. There's none of that, whether it's your own client who's a witness or whether it's the expert. You can talk about it in very general terms, but that's it. You're not allowed to help them prepare. And again, that's why you want somebody ideally who's had lots of experience already, so that they're fully prepared and ready to participate in what is an adversarial process.
That's interesting. And then that shadow expert thing is very fascinating too. I mean, I could see in the US, if the system was like that, there would be lawyers that would try to get around that in some way, such as, I can't prepare this expert, so I will hire someone else to prepare them for me. I mean, it can get really crazy, complicated, and expensive.
It often does, if you can imagine. And people use shadow experts in two ways. One, to help you pose questions to the joint expert, but also if you're not confident or pleased with the outcome of the joint expert who's been appointed by the court, then you get your shadow expert to produce a report, and you say to the court, actually, you make an application to challenge the expert evidence that's already before the court. You say, actually, I have this other valuation. I think it's more accurate. I want that to be introduced. So in some ways, it's a the idea is that you have a more streamlined system, but the reality is that where money is involved, people will try and get around it however they can. I think, Melissa, something you mentioned to talk about, and I think is important, is also understanding the expert on the other side, and what they might be thinking about. I think probably from the US side, you have more to say about this. But one thing I would add is, just in general terms, just be very conscious of the milieu in which you're operating, and whether there's any possibility that your expert might be influenced by, for some reason or another. It's less likely with a legal expert, but if you're talking about a value or something like that, are you dealing with a client who has lots of reach or sway in a particular business community? You want to make sure that your expert's going to be impartial, that they're not going to produce a report that they think is going to be more in favor of one client or another. Just
the other I like this concept, Elizabeth, about really thinking and knowing the other expert. And there's different ways. Like, I've done it where you challenge their expertise, but you could also not challenge their expertise and let them testify, and then actually in the questioning point out that they don't have the experience, point out that their report does not consider the local rules, point out that and actually get their testimony to be stricken in that way. So there's different strategic ways of doing that, not just at the outset, when you're doing that. And again, whether you can call it a shadow expert or consultant, but sometimes those folks can help you with that strategy, if it's a possibility to do.
I mean, that goes excellently right into our last tip, to be even more prepared if you have no expert, because of the cost. And I see a lot of litigation in my jurisdiction where one side hires an expert who gives an opinion, and there is no competing expert to give some contrary or more balanced opinion to balance or neutralize the other expert. Because depending on the issue, you might be able to pay someone who clearly has a slant towards what your view may be. So using Kelly's strategy, I mean, it may be that you can, if you research sufficiently well and you have already done your homework and know the content and the substance really well, which might involve having a shadow expert or a consulting attorney or some other expert in your side, if you can afford that, to be able to cross-examine the other expert and almost either minimize what they have to say or get them to admit certain deficiencies that then highlights what your expert that you can't have might otherwise have said if they were able to be there or testify. So, I mean, there are ways to challenge them and almost twist them to be your expert. Or I've had situations where my client has waffled because of money and they couldn't hire an expert at the outset. And so we designated no one, and therefore that should obviously preclude an expert from testifying. But I had an expert come and sit in the courtroom to listen to the other side's expert, and the judge would allow them on rebuttal, even though I didn't designate them. Or they would have been able to advise me otherwise on my cross-examination because they just heard the direct exam of the person who testified on the other side. So there might be ways that even without you having an expert, because let's be honest, there might be someone that has the expertise you want to put forth, but maybe their English is not fluent. Maybe they don't come across under cross-examination well. Maybe, they're giving you great information and advice, but they are just not the person you want to have on the witness stand in an adversarial court proceeding, but they might be able to give you what you need to use the other's expert for you. Any final thoughts in the final minute from my experts?
I think one of the things is, if you have a client who really can't afford experts, reach out to your attorney colleagues, reach out to your network, because they may be able to help you find someone who's willing to, do a limited role or willing to do something pro bono. Because when I know that we have someone signed up who's from Sanctuary. When I worked at Sanctuary, we didn't have the money to hire experts. But if you call someone who is an expert, and you explain to them what it is you're trying to do, there are a lot of really great, incredible people out there who are willing to donate their time and their effort and their energy to doing the right thing. And don't discount that. There are people who will say, I can't, function as your expert at trial, but I'm willing to give you 4 hours to help you in your case. And sometimes that's enough of what you need to get you the push that you will get the right result. So don't discount your own network of colleagues out there.
What great final advice. I think we are at time. I just want to let everyone know that this has been recorded. It will be made accessible to everyone. So you'll have the resources we discussed on the initial slides. Of course, were our law firm's websites. You should feel free to visit those and let us know if there's any expertise you need from any of us. And I want to thank everyone for being here, but particularly for Elizabeth, Kelly, and Medita. You are just amazing. And thank you so much, because I know how busy all of you are right now with all of your own cases and everything else. So thank you.
Thank you, Melissa, for organizing and including us.
Thank you so
Yes.
much.
Thank you, Melissa.
Thank you so much, everyone. Thank you to all our speakers for the time we've dedicated to present today's webinar. I'd also like to thank our attendees for your participation. And if I may, I'd like to take this opportunity to also announce our upcoming events. So we're going to have a 2-part webinar on international prenuptial agreements protecting mobile spouses on June 10th and June 17th. And then the family law section is having its summer meeting in Boston from July 11th to 13th. And the international section is having its annual global conference in Seoul, South Korea from November 13th to 15th. Thank you so much for choosing your State Bar Association, and enjoy the rest of your day. Thanks, everyone.